I'm a huge proponent of written agreements. My motto is, if it's not in writing, it does not exist. So today I got you.
My faith will rise. I'm crawling out the trenches, holding me.
Hello, visionaries. Welcome back to my channel. My name is Maresa Talbert. I'm the founder and CEO of Talbert Law Office, your favorite go-to legal resource for all things business, nonprofit, and intellectual property law. So as you can already see from the title, today we are talking all about contracts. Contracts are one of my favorite topics because I find that they are so often overlooked. The law is very clear on the fact that it allows people to freely negotiate and enter into agreements on their own terms. So generally, what you agree to in a contract would be upheld in a court of law because the courts do not want to decide what's considered fair or not. Instead, the courts focus on interpreting what was intended by the parties when they entered into the contract. With that being said, I'm a huge proponent of written agreements for everything. My motto is, if it's not in writing, it does not exist. When I write a contract for one of my clients, I schedule a meeting for us to go over the contract and for me to explain every single provision and every line of the contract so that they fully understand and know what they're entering into and they don't just accept it because I wrote it. And I often hear that had we not reviewed the contract together, that they would not have understood most provisions in the contract. So today I got you. For the purpose of this video, we are going to define a contract as a written agreement that outlines the intentions of the parties who sign the agreement. Are we clear? Today, what I want to do is I want to translate common boilerplate language that might appear in a contract. And what is boilerplate, you ask? The term boilerplate is just referring to the standard sections at the bottom of the contract, or at the end. So without further delay, let's jump right into it. So I conducted a quick Google search for the first templated contract that I could find. And since most people think that it's a good idea to use these random online templates, I will use that for our discussion today. Okay, if we scroll down here to the bottom, we're going to start with section 23, titled No Exclusivity. The parties acknowledge that this agreement is non-exclusive and that either party will be free during and after the term to engage or contract with third parties for the provision of services similar to the services. Without having read the rest of this agreement, I already know what this is talking about. This provision is speaking to the fact that the relationship between the parties can be either exclusive or non-exclusive. Obviously, if you say that you're in an exclusive relationship, then it'd be like,
either we're going to be together or you're going to be with me. And I'm going to give you an option because I'm the type of person, I'm going to give you an option, but you're going to either be with me or I'm going to be with you. Or we're going to be together. Yeah.
Depending on the way that the provision is written, it means that the parties can either enter into or cannot enter into similar or the same type of agreement with a third party. Y'all are in a committed relationship to each other and each other only. Let's take, for example, Karen sells her homemade pottery and she got a deal with Macy's, and Macy's is going to sell her pottery in their stores. In the agreement between Karen and Macy's, Macy's might have a provision that says she can only sell her pottery in Macy's. She can't sell it in Pier 1. She can't sell it in Pottery Barn. She can't go to any other store and sell it in any other store. They want to be the exclusive provider of her pottery. On the other hand, if you're non-exclusive, you're giving someone the Heisman, like. That means that the parties can date whoever they want to. Or, in the case of a contract, they can enter into an agreement of the same type with anybody that they choose. Okay, moving right along. Section 24 is titled Notice. I'm not going to read this section, I'm just going to explain it. A notice provision basically defines what notice is and how it must be provided to the other party, whether that's in writing, whether it can be through email, or whether it has to be via postage mail or fax. It also provides the addresses for where a notice must be sent. All right, Section 25. Oof, this one confuses a lot of people. With an indemnification, one or both parties agree to cover the cost of certain disputes related to the contract bought by third parties. That is, people who are not a part of the agreement. I'll give you one example. Let's say you started a podcast and you have a guest featured on your podcast, and this guest says something derogatory or untrue about a celebrity. And now the celebrity wants to sue you for defamation. You'd hope that your contract has a well-written and enforceable provision that requires guests to indemnify you if they infringe on someone's rights or for other claims. Why? Because you'd be thinking, I wasn't the one who said anything about you. You need to send that energy on to the guest who actually said it. I did not defame you. They did. In that situation, you'd want that guest to cover the cost to defend you in court for that type of claim. Make sense? All right, moving right along. 26 is modification of the agreement. This clause just states that any changes made to the agreement must be made in writing and signed by both parties. Pretty self-explanatory. 27 is time is of the essence. This means that this agreement is attached to some sense of urgency. I'll use myself for example. When I'm providing legal services to my clients, there are deadlines for many of the filings and the correspondence that has to be completed on their behalf. However, if I need information from them and they're not responding, then it hampers my ability to do my job effectively. And they may be penalized for missing a certain deadline or not filing something on time. And I'm not going to be held liable for that. That's on them for not doing their part. And so for me, I need to have a time is of the essence clause in all of my contracts, letting the other person know that this is a contract that's based on timeliness and urgency. Number 28, assignment. This just states that the parties cannot designate someone else to fulfill their obligations in the contract. For example, using myself again, if someone paid me to provide legal services, I can't tell them that ABC law firm is going to handle their matter. They paid me to do it, and I'm responsible for meeting the obligations. Many people interact with this provision when they're renting an apartment. Most apartment complexes do not allow you to sublease or assign your lease. When you assign your lease, you essentially transfer the entire lease to a third party, and you are passing on the obligation to another person who was not a part of the initial contract to pay the rent every month. You understand? All right, let's keep moving. Section 29, entire agreement. This just states that whatever is written within the four corners of the document is the entire agreement. The conversation you had at lunch with your boss who promised you that promotion is not written, and it is not a part of the agreement.
My grandmother came to this country with $20 in her pocket. She worked hard her whole life and never took from anyone. When she died, she had turned that $20 into $2,000. That sucks. You know why she didn't succeed? Because she didn't take from anyone. The key to success, and we'll not teach you this in business school, is taking. That's exactly what I've been doing for the last 8 years, and it's all about to pay off.
This is Nick.
I'm this close to getting a big promotion with my own office.
I'll be right there, Mr. Harkin. Morning, everyone. So, I have finally decided who I want to be our new senior vice president of sales. He's right here in this room. It's me. What do you say? I've decided to absorb the responsibilities of the senior VP position into my own. I've realized that if you want to get something done right, you've got to do it yourself. So I'm going to be breaking through the wall of the office that would have been the senior VP's and make one huge, enormous office. However, I will only be taking 85% of the additional salary I'm entitled to, and that is self-sacrifice, people. Meeting adjourned.
Mr. Harkin, can I speak to you?
Yeah, sure. What is it?
You know, for months you've been hinting that I was in line for that promotion.
And look how hard you've been working.
We Just lying to me?
Lying? No, Nick. Motivating. I mean, look, we're all part of the same team here. Plus, I'm the one who's going to be doing all the extra work.
You know that last month you made me work so late I missed saying goodbye to my gam.
I'm sorry, what?
My grandmother. I told you that I needed to see her because she was very, very sick. You said if I left early I'd get fired. And she died before I made it to the hospital.
I'm sorry.
Thank you.
I had no idea that you called your grandmother.
Next, Section 30, Annerman. This is basically just saying who is bound by this contract and who it's intended to benefit. Specifically for this contract, it states that not only does this contract benefit the parties who signed it, but it also binds the parties who signed it, along with their heirs, so their children's children, their representatives, their successors, and their assigns. So this contract would not only benefit, but it would also bind any of those types of entities to the terms of this contract. I hope that makes sense. Section 31, Titles and Headings. This just states that in the court of law, these titles and headings are not meant to be interpreted as part of the contract. They are just there to guide the reader and they have no special meaning. Section 32, Gender. This section speaks to the fact that the use of masculine or feminine pronouns within the body of the contract are not to be taken literally. That the term he in the contract could actually refer to a she in real life. And that the contract should still be enforceable either way. Number 33, governing law. Governing law means what it says, that the contract will be governed, interpreted, and construed to the laws of whatever state. This is very important. When you are signing contracts, you need to look at the governing law, because if there was ever a dispute over this contract, those laws would be the laws that are used to enforce the contract. And generally, if those are the laws that are being used to enforce the contract, if you had to go to court, more than likely you have to go to court in that state where the laws will be enforced. Because California is not going to enforce laws from Kansas, and Florida is not going to enforce laws of Delaware. So if a contract says this agreement is governed by the laws of the state of California, then if there's a legal dispute, you're going to court in California. Even if you live in Massachusetts, just letting you know. Thank me later. 34, severability. This provision says if there's something within this agreement that is illegal or invalid, don't invalidate the entire agreement. Just invalidate that small portion and keep the rest of the agreement intact. And last but not least, number 35, waiver. So a waiver permits the parties to forgo enforcing their rights in an agreement or giving up the right to sue for breach. However, normally waiver clauses state that just because they waived one right one time doesn't mean they waived that same right in another instance, or does it mean that they waive all of their rights under the contract. I'll use myself for example again. In my client engagement agreements, I have a clause that allows me to report late payments to the credit bureaus after 30 days. I have never done that to a client. I have never reported them to the credit bureaus for being late for more than 30 days. And I've had clients who have paid late past 30 days. I have never enforced that. So I've waived my right to enforce that. The next time they do it, I can still enforce that right and report them to the credit bureaus if I choose to. And that is what waiver is generally. All right, so that's the end of this document. There are so many other boilerplate provisions that I could discuss, but this video would be more than an hour long. If I get 100 people tell me that they want a part 2, then I'll do a part 2 with a whole different set of boilerplate provisions. But until then, that's all I have for today. Thank you so much for watching. I hope that this was helpful. Make sure to give it a thumbs up. Leave me a comment below if you have a specific contract provision that you're like, I have no clue what this means. Let me know in the comments. And as always, this is Talbert Law Office, your favorite go-to legal resource for all things business, nonprofit, and intellectual property law. I'll see you in the next video.
I done made it this far.